at the University of Ghent, which is one of our partners. And she graduated in legal practice in Diepenbeck, if I can read my Flemish. She's a master in laws from Antwerp. And so she comes with a different background than from our previous talks, but the topic is nevertheless very important for our activity. So as a data protection officer at Ghent, she deals on a regular basis with the issues that with which we also struggle here in Portugal and within the Elixir Portugal. She's going to bring us her experience. I understand that she's an ethics expert also for the European Commission, and she's been working with the Flemish universities on these topics. So I think we can be very happy to have Ellen to express her views on this topic today. Okay, so without more formality, thank you, Anne, very much for accepting to speak to us today, and I'll give you the floor.
Thank you, Mario. Thank you all also for the invitation. As stated before in the very nice introduction, I'm currently working as a data protection officer at Ghent University. I have a legal background. I'm trained as a lawyer, but most of my daily work focuses on research, and it also goes a lot about health research, medical research, which inevitably involves the processing of personal data. And this brings us to my current talk about the GDPR and health data. Now, the GDPR is a general data protection regulation, which you all are pretty familiar with. It has a ton of rules, and some of them might feel very much as an administrative burden. It's legal rules, it's lawyer talk, it's stuff you need to be compliant with without fully understanding what the purpose of this compliance is. From a more ethical point of view, what's the purpose of this more than just being compliant and being okay in respecting this specific legislation on privacy? So in this talk, I would like to focus on GDPR and health data, and I would like to try and clarify the actual purpose of the GDPR to help you understand the end game of GDPR, which will in most cases be certain rules that we need to apply when we are working with this type of personal data. Now, as GDPR was not written, at least not at large, for scientific research purposes, we need some translation to bring this into practice. So I will try and give you some examples to make it very clear on the scope of this legislation. And I will do this by beginning to clarify what I mean, what I understand when I'm talking about health data, what the GDPR scope of personal data and the link with health data is. I will then focus on the basic principles for processing personal data. And these are the core principles when you need to understand if you're working with this data and if you want to understand why the data protection officer of your university is emailing you saying that you need to do this or you can't do that. Same goes for partners, universities. This is the basic principle of understanding the GDPR. I will then discuss a few good practices, things that when I was preparing the session crossed my mind that might help you in the working field when you're conducting research and working with personal data. And of course, I'm very happy that we can end with a question and answer, hopefully answer session in which I'm happy to have a discussion with you from your expertise and how you can address this in practice, and maybe have a short discussion on some questions that I didn't discuss during this presentation. So first of all, when I'm talking about health data, I'm talking about personal information or personal data. When you're talking about GDPR, you're always talking about personal data. And if we're talking about personal data, this means this is data that's related to a natural living person. This is very important because personal data can still be related to a living related to a natural living person. But if it's personal data that's not related to a living person, but that's related to a deceased person, the GDPR shall not apply. So in this session, I will be focusing on personal data that relates to the health status of a person, referred to as health data. Health data is very large. It includes medical data, such as doctor referrals, prescriptions. It also includes test results, radiographs, and it also includes clinical information, phenotypic data, can be phenotypic digital data as well. It also includes administrative and financial information about health, like when did a certain patient come to a clinic, how many times did they visit the clinic, at what time, because this is information, if you look at it in particular from a research point of view, if you collect this data together with other data, this might lead you to be able to identify the person this data belongs to. If you know that I'm visiting a certain type of special clinic for special diseases, and you know all the times that I've been there, you might be able to identify me as a person if you can bring this together with other information. That's why all these types of information that I've put in this slide are seen as health data, even if they're coded. And that's a first important thing to understand when we're discussing health data, that all of this data that I mentioned on my slide, you can treat it in a way in which it shall not relate to a natural living person anymore. Because, for instance, you have the time that I arrived at the clinic, but you don't have any additional data. Just by knowing that one person was in this clinic, you cannot identify this person. But if you know that this person was in this clinic and you know the address, or you know the gender, or you know the height, or you know their appearance, then that can lead you to identify this person. Now, diving into health data, something that's very common in the medical sphere and in research is that we tend to work with this data in a coded form. Most simple example is you have tons of medical data, health data about a natural living person. And you do not, if you're working with this data is not always in its form for analysis linked to the name and the address of this data, of this person, but it shall be linked to the patient number or another numeric code or random code that has been assigned to this specific person. Now, when we're talking about health data, and we have these types of codes, even if it is coded, this data will still be personal data. The only time when health data is no longer or not seen as personal data is when it is treated or has been treated in a way that it is no longer, that it can no longer reasonably be linked to a natural living person. And this is very important to understand, because it's common practice, at least in Belgium, to have tons of data about patients. And when we're working with them, you want to be able as a researcher to identify this participant of your research. So you will give them a code. As long as the code can still be linked to additional information that can lead to the identification of this person, it will still be personal data. So working with codes is a very good step in the first direction, but it will not lead you outside of the scope of GDPR. Looking at health data in scope of GDPR, health data is sensitive data. It is called a specific special category of personal data in the GDPR. When you're working with health data, it's not anonymous data, so you can still link it to the person. It will be seen as special category of personal data. GDPR will apply. When we are working with special categories of personal data, there are some other legal questions that will pop up, which is that you need to be more sensitive. When you have a data breach, let's call it normal personal information, like a person's name or address, the impact will in most cases be lower if it's normal personal data, but if it's sensitive personal data, if it's data about a person's mental being, a person's health status, and something goes wrong, the impact will in most cases be way more severe and way stronger. That's why the GDPR truly addresses health data as sensitive data, special categories of personal data, in which some other conditions need to be met. Now, what we can conclude from this slide is that we now know that all this type of data is health data. Even if it's coded, it will most likely still be health data. It's personal data, it's even sensitive special categories of personal data. So we need to apply the GDPR. But I don't think I'm saying anything new, bringing anything new to the table up until this point. Now, when we are looking at the processing of this personal data, first of all, I want to clarify that processing personal data, processing health data, is a very, very large definition. If you're looking at it, if you're working with it, if you're analyzing it, if you're changing it, if you're deleting it, you are processing personal data. So, for instance, if you are working together in a research setting and you're exchanging data, but you're not sending a file from one researcher to another, but you're having this data on a SharePoint where both of you can access this, the access to a collaboration SharePoint where you can both download data is also still processing personal data. So almost everything you do with regards to personal data, health data, will be seen as processing. Now, all the rules and particular questions the GDPR will ask you when you're working with personal data, with health data, they can all be brought back to these 7 principles. These 7 principles are the basic principles for processing personal data. Those of you who want to look them up, they're in the GDPR. I think it's one of the first 5 articles where you can read about these principles. The principles are the bottom of being ethical and working in a fair and transparent way with health data. When I'm working as a data protection officer at my university, I tend to have like a weekly discussion on whether or not privacy and GDPR should be something for the legal department, and the ethics committees, they should only focus on the ethical stuff. We are working more towards working together on this because being compliant to these principles will actually make sure that you are working with personal data in an ethical, approved way. So this is, even though it might feel very legal as a topic, the bottom line is still working towards ethical principles, and some of them are already embedded in genuine practices and common uses in your several disciplines. Starting with the context of these principles, we will start with lawfulness, fairness, and transparency. Lawfulness is the most legal one of them, at least to my opinion, because this means that you need a legal ground. And this is something, if you look at it from outside the research scope, this is the reason why when the GDPR came to force, we all got tons of emails saying that we need to consent to still receive newsletters. Because if you're working with personal data, everybody, whether or not you're a researcher, data protection officer, you or a government, you need a legal ground. This legal ground is very important to establish before you collect your data and before you start working with this health data. It's also very important to keep this lawfulness, transparency, and fairness in mind when you want to get access to data that was collected by someone else. Let's say you want access to data that a health institution has collected on COVID, and you want them to share this data for you because they already collected it, you need it, why not join forces? The legal ground will be the first thing you need to look at when this data is still considered personal data. The most commonly used legal grounds They're limited in the GDPR, so there are only 6 options. At this point in Belgium, the legal grounds that we see most often in research purposes, research projects, and more specific in relation to processing of health data is consent of the data subject, consent of the participants, or public interest. Public interest is mainly used by hospitals to, one, do healthcare, and two, analyze this data also for research purposes. Once you have established your legal ground and you're working with consent, or you're working with public interest, and you can tick those boxes, you will need to be transparent and you will need to inform the data subjects on the processing activities, on what you're going to do with this data. Now, this is not new. When we are working with people, we have been informing them by information sheet and informed consent for years. But what has changed is that now with the GDPR gives us a list of everything we really need to inform these participants about. So it's not just the purpose of what you're doing with this data, but it's also who's the controller, who's the data protection officer, who can they contact. And there are some exceptions for research, but these come mainly when you are not collecting the data directly from the participants, but you're reusing it in another research. So most commonly used are information sheets and privacy statements on websites or on project pages. And this is also important if I go back to my example on when you want to reuse data that was collected by another institution. If they are the ones who primarily collected the data and they want to give it to you to reuse it, they should also be transparent at the point when they're collecting it, so that people who give their data to them know that it will be reused for research purposes. So that's something you want to look at the very start of your research design. When I give my trainings at Ghent University, we have a slide which is like a checklist of everything you need to fulfill and think about when you're working with personal data for research purposes. And I can tell you that most of the to-dos are in the planning and designing phase of your research, because the more attention you spend on looking through these principles and making sure that these things are in place, the easier it will get when you want to reuse your data, when you want to share it, when you want to do other stuff with it. So you really need to understand that the biggest burden lies at the very beginning. The more work you do at the beginning of your research project with health data, the easier it will be to be flexible in working with this data from the outset of your research project. The second one is data minimization. This means that data cannot be collected for other purposes unless it is essential for the research and its goals. Now, this is a tricky one, because when you're conducting research, at the beginning of your research, it's in most cases that my researchers tell me, at least, they don't fully know all the data they will be needing. This is something that may evolve around time. They have a fair idea of the data that they will need, but it can be that a different idea of they get an insight and they will need additional data. So this is a principle that we need to approach from a flexible way when we're looking at it from a research point of view. What this does mean is that when, for instance, you're working with personal data, health data that you're collecting from a patient file, at our university hospital, we work with electronic patient files. Applying the data minimization principle means that if I'm the researcher and I need data from the patient files, that I can say, okay, I need these 5 types of data for this reason. And that's being compliant with data minimization. Breaching and not being compliant with data minimization would be, hey, give me access to this patient file and let me just go through let me just take a copy of the full file, and then I will see what I can do, and then I will delete what I don't need afterwards. That's not truly being that's not truly processing health data from a data minimization point of view. You need to do this thinking exercise as much as possible at the beginning before you start accessing all this type of health data. The third one is the purpose limitation. And this means that personal data must be collected for explicit, legitimate purposes, and it cannot be processed in a way that's not compatible with the reason it was processed. For instance, let's say I am doing research, I recruit my volunteers, healthy volunteers in a health institution, and in my informed consent form and in my information sheet, I say, okay, if you participate and you give me your consent, I will only use your data for this research, and I will not use it for any other type of research, only this one specific survey. I get consent. A year after, I want to reuse this data for another project also in medical health research, but on something very, very different, something very, very contrary to the first thing that I signed up with. Let's say I give my consent to the first survey to be questioned about the ways, how fast that they are doing their medical treatment in the hospital. And they ask, one of the questions is, which medical treatment have I undergone? And then they re-contact me without further ado to have a very specific research on a very similar or rare disease that I might have. This is not compatible. You need to make sure that when you're working with health data, that it all falls within the line of expectations, the pattern of expectations that was created. You have this purpose limitation. Now for research, if you are reusing data, the GDPR is kind of flexible, as it says that if you're reusing data for research purposes, it's almost, you can assume that it's compatible. But there are some tricky sides to it, which I will discuss in one of my next slides. Okay. Coming to the next basic principles, integrity and confidentiality. Now, when you're working with health data, chances are that you're also doing a medical profession and you are bound by professional secrecy. In addition, GDPR says that you must treat data with integrity and confidentiality, which means that you are in charge of making sure that you have codes in place, that it is pseudonymized, that it is encrypted, that you can really show that your data will be kept confidential and to the level of confidentiality that's required. The other principle is storage limitation, which means that you cannot keep personal data for any longer than you need it. Now, in practice, this means that if you're doing a survey and this will last for a project and the project will last 5 years, the starting point is that you don't need this data after the first 5 years, and that you delete it afterwards. Now, as we know that most research outcomes and the data can be valuable for future purposes, this is something you need to think about at the beginning, say, okay, how long do I want to keep my data? Because I have this storage limitation. Unless you foresee that you can keep it longer in your information sheet, in your consent form, and in the information and agreements that you are making with your research participants. Data must be accurate. This means that if data is inaccurate or incomplete, your data subjects must be able to ask you to correct this. This does not mean that if you're doing research and the outcome of your research is valid and the research participant does not like it, that you will need to change it in favor of their opinion. That's not what accuracy means. Now, the last and probably from an institutional point, most valuable one is that what GDPR has created is it has created accountability. This means that if you're the one collecting the data, processing the data, sharing it, reusing it, in each step of the way, if you're working with personal data, you as a researcher will be responsible for complying with the GDPR, and you must be able to demonstrate this. Now, I hope that for you as same as in our institution, you can get help with this from legal departments, from your data protection officer, you have training. But having this thinking exercise, going through the 7 principles, okay, what will my legal ground be? Will I be sharing it? How long do I need it? This can really help you if you put a short documentation on it to avoid future errors or to avoid mistakes on what can and cannot be done with the data. Because one thing I can tell you is that it's very hard if the harm has already been done to look into research data and to see that the right provisions weren't taken and that research data must be deleted or cannot be reused or it will go to waste. I think what the current pandemic has taught us is that there's still some room to think about future use of data and to not be collecting this data in this country and this data in that country, or even within one country. All institutions are doing the same, but sometimes the provisions aren't in place to just share it and have a greater cause with all the data together. So being able to demonstrate your compliance is the large part of this accountability principle. Going back, and I'm almost through my slides I have. This is almost the last slide. I just have one more left. So I think I will finish in time. So we have more time for questions. One of the good practices is to fully really comprehend the difference between anonymized, and pseudonymous data. I often see the term pseudo-anonymized data. This is a term that does not in GDPR language exist. Your data, it's personal data or it's not. It's pseudonymized or it's anonymized or anonymous or it's not. There's no in between. When you're working with anonymous data, this means that there's no reasonable link to natural living persons. If you're working with data and you call me and you say, oh, but this data is anonymous, I don't have the codes, the institution has the codes, most likely data will not be anonymous. For data, there are exceptions, but in most cases, when the key files and the codes still exist, this means that someone will still be able to link this data back to the person, even though this is not you, this is someone else from who gave you the data or another institution. In most cases, this means that it's reasonably possible to go back to the identity of the natural living person, so data will not be anonymous. Data can be anonymized, which means that the code or key files, they did exist, but they don't exist anymore. They have been deleted. You cut the link between the identity and the data. This is something, for instance, that I see EEG data and radiographics being done where they delete the code, they delete everything, and that it cannot longer be linked. So there are ways of creating anonymous data, but the important thing to understand is that up until the point where your data is or has been anonymized, you are still working with personal data. So if you are collecting the data and you're doing the anonymization yourself, GDPR will still apply. You will still be working with personal data. It isn't up till the point that your data, your key files, your additional data, the link has been removed. Up until only starting of that point will your data be anonymous. This means that in most cases, it's a good practice to, if you're getting data from another institution, another researcher, to have them anonymize the data and give you the anonymized data set. Because in most cases, if you do the anonymization yourself, you will still be working with personal data from the outset, and you will still need to comply with certain of the basic principles, and you will still be facing GDPR, even though at the end, you really don't need to because you only need anonymized data. Your data is pseudonymous. This is in the formal legislation in Belgium. I think it was the case for most European countries. We call this coded data. Your data is pseudonymous when you have additional information. This can be a code, this can be a key file that still exists, but it's kept separate. And separate does not mean in another file on your same computer. Separate really means in another physical location with access not for all people. So this can be the hospital keeping the code and keeping the electronic patient file, and you only getting a part of the data. You yourself will not be able to link this data back to the original patient individuals, but the hospital will. And in medical research, this is actually the case. It's necessary in most cases, because depending on the type of research that you do, for incidental findings, you will need to get back. You will need to have this link to get back to the persons or patients involved. Now, when you are working with personal data that you did not collect yourself, let's say I am a researcher at a university in Portugal, and I want to get data from another institution or even a government institution. It's still personal data. It cannot be anonymized, because in some cases, when your data will be anonymized, you can do anything with it. So if you want to work with data, the GDPR does not have the obligation to anonymize data. It has the obligation to only work with the data you need. So you need to try and anonymize it. You need to think about anonymization, think about pseudonymization, but nowhere in the GDPR does it say that you can only do research with anonymous data. If this is the case, it will usually be because one of the other principles is asking you or prohibiting you to work with non-anonymized or pseudonymized data, obliging you to work with pseudonymized data. So let's say you're getting this data from another institution. The first thing you need to do is check the legal ground that they use to collect this data. The GDPR says that when you're working with personal data for secondary use, when you're reusing it for scientific research purposes, this ought to be compatible. But if the primary institution who collected the data used consent, and this consent did not include reuse for scientific purposes, you're in a tough situation, because in most cases, this government institution will say, sorry, we can't give it to you. So that's why you need to think about the legal ground yourself to see, okay, what was their legal ground? What kind of options does that have for research? If the legal ground is consent, further use for research purposes must be included. That's really the fairest and most honest way to work with, to reuse data, if it is consent. I'm not saying the legal ground should be consent. That's the first thing. You check the legal ground for primary data collection. This also goes when you have a fellow researcher and they did a study in another country and they did a survey and they can give you the data and you can do a follow-up survey. You ask for the legal ground to make sure that reuse was included. If it was consent, it must be in there. Second, whether or not the legal ground for primary collection was consent, regardless of what the legal ground was, you take appropriate technical and organizational measures. Now, this is one of the most vague things amongst many others that's written in the GDPR, because technical and organizational measures, they're not really defined as concrete as we sometimes need them to be in practice. What this means is that you try to anonymize your data if this is possible. Keep in mind that this is a trade act, this is a balancing act. Do not anonymize your data up until a point where you start doing your analysis and you cannot reach your outcome because you can't read your own data anymore because it has gotten so anonymous that it's no longer usable for you to achieve your research goal or purpose. If that's the case, look into pseudonymization. See what of the data that identifies the patients or the participants that you can put aside, but still allows you a way or a method to work with the data that you truly need. That's for the technical measures that you can take. The organizational measures, there are a lot of different possibilities, but the most common one is to limit access to the data, to make sure that this data is not shared with all the researchers in your university or in your team, but only with those who are working with it and only for a limited period of time. Now, when you think about the good practices that I just discussed, and when you think about them before you approach someone to work with their data, this will help the both of you. not only will it be clear for you because you did your due diligence, you did your compliancy, and also for the one who will need to be disclosing data for you, who will give it to you for reuse, they will see that you have an understanding of what's going on and that you are fully aware of what needs to be tackled and needs to be taken care of in GDPR terms to work with personal data, or in this case, special categories of data, meaning health data. These were my slides. It was quite a challenge to kind of invent what would be interesting for this group to have a discussion on, to have information on. My normal sessions are full day sessions where we go into detail and we have discussions, we have cases. The time was too limited for that, but I'm happy to take on any questions and try and see if we can have a discussion on this. If not, I'm always happy to have further discussions or share insights via email. My email is listed at the slide, and I think I can share my slides with Mario or the other partners from Elixir, and then they can be made available to you. So the floor is all yours. Thank you so much for your attention, and I hope it was useful to get us started on some discussion.
Thank you very much. And I don't know if we have anybody interested in raising questions. We have quite some time for discussion. So I think you can raise your hands. That will probably help us. I have seen one raised hand, but if anybody wants to ask, please, you can raise your hands. Anna, you could go first.
Thank you, Mario. Thank you, Hanne. It was a fantastic talk. I have some questions about the storage. That's quite a tricky thing for a research infrastructure like ours, where we build repositories for health data, which in the end we would like to make available for further research. And I have sort of two questions. One is, do we need to have some kind of statement in the consent form that the data still prevails in the repository after the project? And what if we anonymize it for good? Can we just come out of the GDPR and still make our database useful for further research or even further diagnosis?
I think the answer to your last question is yes, and it probably also answers your first one. So the storage limitation of GDPR, it is quite flexible for research, in which case that you can work with time slots and you can work with criteria for the retention period. For instance, sometimes researchers say data will be kept until the end of the project, instead of saying data will be kept for 5 years from the start of collection, because some projects last longer than 5 years and you cannot fully predict this. In other cases, they work with slots where they say data will be kept in a pseudonymous form so that we can still link back to you for 5 years. And after these 5 years, we will anonymize this data. Now, logically speaking, once you have anonymized data, you cannot help a participant to address any questions or concerns or rights that they might have, because you ought not to be able to know who this participant is, because otherwise your data would not be anonymous. So it is very tricky to create a marriage between open data and repositories where we want to share data that's sometimes not anonymous for as long as possible because of the value for research. And on the other hand, we still need to have a system in which data subjects and participants can access their rights, can still say, no, I don't want to be part of this anymore. One of the ways is working with time slots and saying it will be pseudonymized for this period of time, after which it will be anonymized. And once data has been made anonymous, or it is anonymous, as from that point, GDPR does no longer apply. So this means that They have no rights, that they cannot be identified in the whole lot of the data. Now, from an ethical point of view, if at the beginning of data collection, you already know that this is data that you need to keep for a long period and you can do it anonymously, I would still include this in the information form, because I think it's transparency and being ethical of explaining to your participants, okay, we're keeping your data, this is what we're doing with it up until this point, and because we're making it anonymous, we cannot identify you, but we will still, it will be kept timeless. And once it is anonymous, because the individual cannot be recognized, cannot be linked because the link has been made redundant, there are supposed to also not be any risks left for the individual. So if you can get to the point of anonymization, that can be a way out of some of the problematic views. If you can't, the storage of pseudonymized data in repositories and the online sharing, it's, to be honest, it's kind of a gray area at this point. I haven't seen too much repositories or examples where there was a lifelong vision on keeping data, accessing data, subject rights, and matching this all together with keeping data in a repository for several years. At my institution, we urge researchers to think at the beginning, when they are creating their information sheet, do you want to put this in a repository? And they include this in the information sheet. And if consent is a legal ground, it will also be in the consent, so that participants consent to participating in the research, having their personal data processed, and also having the data put in a repository for research purposes.
Thank you.
I hope that answers your question.
Yes, very much. Thank you.
I don't know if you have another question. I'm looking here into the questions. Claudia Conceição has had a question here. I think you can give you the floor. Claudia, please.
I'm sorry. I hope I can express myself in English, but I think you have already answered. My question is to make compatible the policies of open access, including those that are being announced for the future. So I'm not sure if I understood you, but maybe we should advise all our researchers when doing a consent to say that the data is going to be anonymized and will be available for further research. Would that be a good advice to give everyone?
If it's possible to anonymize the data, I think it would. At my university, regarding open access, we have the current policy, and we know it might change, but our current policy is as open as possible, as closed as necessary.
Okay.
So this means that if you're working with personal data and you have consent and you can pseudonymize it and it has no risks, you can share it, you can, but if it's very sensitive health data that's very recognizable and you don't have consent, ethical or legal, it can be if consent is not the legal ground, you have another, you don't have ethical consent, then it's tricky. So we have seen journals, publishers who ask our researchers to share their entire data set before they get to publish. And in most cases, to my knowledge, up until this point, we had a discussion saying, we understand your question. This is sensitive data. We're not going to do this. This is not data that we want out there. And there are possibilities. Some journals are now working with levels of access. Some universities have access committees. So what this means is that you can say, okay, publisher, I will share my data, but only if I have a question from a researcher and in certain cases. Then you get restricted access. You don't need to give all the sensitive data to the publisher, but you will get a request. And then you as a researcher, sometimes ethics committees, they say, okay, what's the request? What kind of research do they want to do with the data? Okay, this is fine. And then you can give pseudonymized data, not raw data, to the researcher. So we are moving towards a way, but saying that everything needs to be open, I don't agree. But saying that everything needs to be closed because of privacy, I don't agree either. So we need to be in the middle, and we need to think about this, because publishers, and journals, they should also not want to have all this type of sensitive data just in case they might need it. That's not the way to handle some types of this data. So the way of working with it, I think what we have at our university, as open as possible, as close as necessary, I think that's really, really fair.
Thank you.
You're welcome.
Do we have more questions? I do have a few, if nobody has more questions. Regarding consent, and I don't know if you clarify this, but let me ask you explicitly. Can I anonymize data without consent? Let's say I have data and decide to anonymize it without asking for consent, and then keep the anonymized data.
It depends what your legal ground is. When you're looking at consent, we have two types of consent. You have consent from an ethical point of view. This is consent to participate to a clinical trial, to a research project. Then you have GDPR consent. GDPR consent is your legal ground for processing. I don't know about the ethical consent. Sometimes I see ethics committees giving a consent waiver. Sometimes they still want consent. But for GDPR point of view, if you have another legal ground and it's not consent, it's good practice to inform them. But if your legal ground is not consent, you don't need consent to anonymize data. It should be in your other legal ground. But I think the problem with doing this will be the ethical consent, where an ethics committee might say, wait a minute, you need consent, or they might give you a waiver. This is something, the way ethics committees deal with GDPR type of issues is very, very different, even from within countries in the EU, but even within a country in different universities. And even in my university, the different ethics committees sometimes disagree or have different views. And I think that's okay. We need to be keeping an open mind because it's moving. So from a GDPR point of view, if your legal ground is not consent, you don't need consent, but you need to have another legal ground that clarifies this.
Thank you. Another question, and you were kind of touching it, is, but I would phrase it this way, is what are the exceptions for health data, or in what aspects does health data differ from data in general under GDPR? Because it looked to me that you were basically saying what GDPR states for every kind of data, and of course it applies health data, but there are some exceptions, right?
There are. Yes.
So maybe you could summarize that and say what are the main things that you need to worry about?
Well, in some cases for health data, when you're working with consent, and I think it's minors, it needs to be explicit. It needs to be more explicit than if you're just working with personal data. Consent is your legal ground. It needs to be active. It cannot be pretext. It needs to be an active affirmative action. But if it's health data, it needs to be an active affirmative explicit action. It needs to be in there that it's health data. The most important thing to consider when you're working with health data is that when you're working with personal data, you need a legal ground. When you're working with health data, you need a legal ground and an additional exception ground from Article 9 of the GDPR. In most cases, you will say legal ground for processing personal data and health data. It will be consent, public interest, and then you pick one of the exceptions from Article 9. Because health data, because it is seen as so special and sensitive, the GDPR starts from a default setting that you cannot process health data. So Article 9 says you cannot process personal data, health data, sensitive, special categories of personal data, unless you have one of these exceptions. And that's why you need one of those exceptions. And in some cases, some funders, if you are processing health data, they will ask you for your exception ground. This will be Article 9, scientific research. It needs to be in a national law, or it can be healthcare for when it's together with the university. And then they can also ask for a justification, because they want to know, why is it that you need this sensitive type of data? And in some research projects, it's very clear. When you're working, you're doing medical research, you'll need health data. If you're looking into cancer, you need health data. But in some disciplines, mostly cross disciplines, where let's say someone from the medical department is working together with someone from the engineering department, and the engineering department, if they do the application, they can ask them, why do you really need health data for this? Can't you work with dummy data? So I think working with health data, you need to check the Article 9 exception. You need to look into children. Children is a different setting as well. Consent will most likely need to be explicit, and you will most likely need more technical and organizational measures. They will be even more strict. In addition, health data, and this is not GDPR, this is not me as a DPO, but just from my experience, most of the times there are national additional laws that apply. You have GCP, we have other national legislation, for instance, GDPR has Article 89, which is about scientific research, and some parts are not explained in GDPR. You can create national legislation on this. We have national legislation. It doesn't say very much for most types of research, but for health research, it does have some additional things that need to be in order. So I think that's the fifth thing to check, is national legislation specifically pertaining to health data. So these are the 5 things that come to my mind when I'm looking at, okay, health data, what do I need to take into account additionally, besides the GDPR basic principles?
Okay.
Mario, can I
Sure.
make some more questions? Thank you. Hanne, I have 2 more things. One that goes a bit beyond the GDPR, and this is about data sharing sensitive data across borders. In the Elixir, we have this European Genome Phenome Archive that you may be aware, and the implementation of such a federated repository poses many questions. Could you comment on that?
Well, I can sure imagine how difficult it will be. I think in most cases, it is tricky to cross-border exchange sensitive or health data because it is so sensitive. I don't think it's impossible though. I think if you have a good data management plan and you have a good GDPR registration and a flow on how you will work with this data, you have your legal ground and you have your goals and everything set out, you find tools that are in the European Union and restriction, and you work with a protocol, I think it can happen. I'm aware of some projects that are planning, they're looking into how can we create this type of database. Most of the researchers working on this that I've talked to, I haven't seen their end product yet. To my opinion, I think this is also something that's so groundbreaking that sometimes institutions are maybe for the past a bit hesitant about it, not really seeing the potential, but more seeing the risks adhered to creating such a thing. So I think we should keep trying and create this, and we need to get legislators and data protection authorities on board, because this is something that we need. It can happen. We just need to think it through and create the right setting, but it is tricky. I've heard several projects trying to establish this, and it's not easy, but not impossible, to my opinion. But it will also need, I understand that it might feel a bit odd, but it will also need a very good legal partner to really think about GDPR. And I'm not talking about a legal partner, just someone who knows GDPR. You will need someone who knows GDPR and research. Because this is something that I see that we are struggling with at my university at sometimes, that you have the law on one side, but you have research on the other side. And if you're working with lawyers or experts who are not truly aware on how research works and are not willing to think outside of the box to make it happen, but still be compliant, you will lose so much time and sometimes also a bit of money trying to create something that's just outside of their scope. So it needs a very good collaboration with the researchers explaining their idea, some IT explaining how it could happen, and a legal person thinking from a data protection point of view and a security point of view as well. But I can imagine the challenge.
Yeah, and the second question would be that from time to time we hear that sensitive data is published openly without following the rules. I think sometimes it is because of ignorance, sometimes it is because this is such a complex process, but ignorance comes in again. So what can be done to improve this?
Do you mean to act once it has happened, or to make sure it doesn't happen?
Both. So if it has happened and I know about it, to whom should I say something? And not seeking for punishment, but seeking for justice.
Compliance.
For lives are exposed, something like that. And on the other hand, also for these greater campaigns of raising awareness of how should effectively treat these matters without being too strict, but not over crossing the line.
Well, first of all, if you come across a practice that's not fully in line with what the GDPR prescribes that should happen with personal data, I think a good point is always the involved researcher and the data protection officer from his or her institution. It happens everywhere. If a DPO says it doesn't happen at their institution, they just don't know about it, because we are people, we make mistakes, technology can fail us. So it can happen. And what's important is that you know how to act when it happens. And when you're the one it happens to, you need to know who you can turn to within your institution, being your data protection officer and your IT department, to help you solve whatever has happened. If you're the person who outside of the project and you see something went terribly wrong, I think I would address the data protection officer of the institution. And if it's gone terribly wrong, you can go a step higher, and that would be to contact the data protection authority, but that would be making a complaint. And even though I fully trust data protection authorities to help enlighten the privacy standards from their territorial scope, sometimes it can easily be fixed by just discussing it with the data protection officer. It happens at my university as well. Something goes wrong. People, sometimes they're data subjects. Sometimes they're just people who come across something that's online that's still open. They email me, I contact ICT, and I make sure that it's solved. For preventing this to happen, I think you really need some guidance. And I'm not just talking about a person who can guide you through this. I'm talking about online written guidance for research, that you, if you're looking for it as a researcher, that you know where to turn to find basic information. The other thing that I found very valuable is that at our university, as in most of the universities, I think almost all of them in Belgium, the ethics committees, they don't give a clearance if you have not made a registration in the GDPR register of your institution. So this is also a way of working together. So if you want an ethical approval from one of the ethics committees, even for the medical ethics committee, let's take this one as example. If you want an ethical approval from the medical ethics committee from our university hospital, you will need to prepare a lot of information depending on whatever research, if it's clinical trial, if it's not, whatever you're doing. And in addition to that, you will need to provide them with a copy of your GDPR registration. And that's the first place where you as a researcher get guidance and you think about, okay, am I processing personal data? Is it sensitive health data? Is it from children? Is there any national legislation that I need to look into? Am I sharing it? How can they reach me? These type of things, that really helps. It's a hard thing to expect all researchers to become half legal lawyers and knowing how this works. But I think what we can expect them is to have a reflection on, wait a minute, this is my data, this is my research. Who can help me with this? I think this will be a problem. How can I find help? And then it's up to the institution and the environment to make sure that there is help there. And that's a challenge. I'm the only data protection officer for approximately 2,500 projects a year. So it's tricky. Do we need more? Yes, but it's a beginning to acknowledge that researchers need support, but also to acknowledge that researchers have the responsibility to think about this and to take actions into own hands. I hope that kind of answers your both of your questions.
Thank you very much.
You're welcome.
Thank you. I think we are already past the hour. I had a similar question because I am also head of a ethics committee, and about 80% of my work is telling people that they are not complying with GDPR, and I should start working on. I mean, our work as the ethics committee should start after the legal issues are clear. So I have this question for you. It's more a curiosity. How do you cope at the University of Ghent with the researchers? You were answering that, but in the sense, do you have any kind of formal training and this kind of a structured program where the researchers can learn about what they have to do? Because in many cases, I mean, instead of having the researchers coming to me, I have like their students, master students, where kind of the advisor told them that you should worry about getting the ethics permit, and the students kind of start digging about the subject. There is kind of no formal training for that. How do you do that? Again, I'm very curious.
We do it in several ways, and it's work in progress. It will be work in progress. I started by doing general sessions in which all researchers could come. I did 2 or 3 of them a couple of years ago. Now I do on-demand sessions. So we have 5 data stewards who are appointed to a faculty or more faculties, and they are in the field working with researchers, and they will get a sense of, okay, in this faculty we might need a session on GDPR and online digital data scraping or something, and then they contact me. So I do, most of my sessions are on demand. So these are the ones that are kind of ad hoc, that can happen at any given time. Now, and for all researchers, depending on whoever poses the question, we also have a mandatory traject for starting PhD students, in which they need to have an online session, and a part of it is GDPR. Then they need to do transferable skills sessions, and they are part of their doctoral school's training. And one of those modules is GDPR, where we do a 1 or 2 day training on GDPR for PhD students. The master students and bachelor students, if it's applicable, because we have faculties that don't work with personal data, but where it's applicable, the head of the teaching committees from the education or the master or the bachelor, they need to make sure that in the course of research methodology, there is something on personal data and data management, research data management. So that's in there for them. And at this point, we are working on having online guidance for master and bachelor students. We are just recording, there will be short videos, and then they have a website with more information. And for researchers, we also have a website in Dutch and English, which is really GDPR, but it's in the research life cycle. So you will have a section before the start of my research, and then you will have questions. What will be your legal ground? Who will be your data subjects? How to handle children? How to work with vulnerable persons? When you are collecting personal data, where will you keep it? How long will you store it? And then if they click on this, they get further guidance. The same guidance is also embedded in our online form where they need to do their registration. So we have information that they can always find that's embedded in our university structure, but we also sometimes have on-demand sessions. It kind of depends on what works. Now we are trying, I'm lecturing a class of 300 master students on GDPR to see if maybe we need an extra class or something on this. So it's, we're doing it at multiple ways. We're getting them from all sides to try and inform them on GDPR. And the thing that I think that mostly helps is that they mail me. They mail me, and my colleague from Ghent University is also here. We often get emails if they're really working with a project saying, okay, this is what we're doing, we need some help. And together it will be the two of us helping them or our data stewards. We have a system where we have 5 data stewards. And the agreement is that researchers address the data stewards. They know GDPR, they have had extensional training on it by me. And if they can help them, then they get referred to me, because we have 1,000, I think 7, 8, 9,000 researchers. They cannot all email me. That will not be manageable. So we try to divide tasks by working with this first and second line of assistance. So these are some of the things that we are doing. Together with all Flemish universities, we're also working on creating a short online tool on research integrity, which also has a bit of GDPR in it. So we have permanent online information, we have permanent guidance in our GDPR register, and we have regular sessions and specific sessions. I think that sums up my answer to your question.
Yeah. Thank you so much. So as I said, we are already 8 minutes past the hour. So I think we have to close the seminar here. It was, at least to me, very helpful, and I think the audience is also enjoying it. Okay, so thank you.
You're welcome. Good luck with your research and have a nice evening. Thank you for having me. Goodbye.
Thank you very much, Hanne. Bye-bye.
Bye.
Bye.